So welcome everybody. I'm Bob Carr. I'm the CEO founder of Link SV. We've been tracking companies in Silicon Valley from Santa Rosa to Santa Cruz to Sacramento for the past 25 years, tracking all their venture capital and the key people, what they do, and so forth. So people can use this as a great database of information. Along the way, Roger and I have been friends for many years, and we kind of had this idea: wouldn't it be fun to share some information? So I said to Roger one day, how about looking at a clock and figuring each hour is a different topic? And Roger had that all down pat. So we've covered a lot of topics over the course of the last year, maybe 7 or 8 sessions we've had already. And I think today we're going to talk about M&A, which I'm really interested in because nothing happens until a company gets acquired. So from an investor standpoint, who wants to reinvest the money, by the way, to continue doing good? Okay. So Roger, welcome.
Okay, thanks, Bob. And you are correct. This is number 10 in a session of, okay, hold on here. Tell me when you see my screen, when you see my first slide.
I'll be happy to tell you that.
Do you now see my first slide?
I do not. Nothing yet.
You don't?
No error. No takers there. Fireflies.
No kidding. Sorry, everybody. Sometimes it works and sometimes it doesn't.
It's generally worked in the past, but I'm seeing nothing. Oh, here we come. We're coming. Now I see a bookshelf there and legal strategies for startups.
Is it in presentation mode?
It's am I supposed to see presentation mode? I don't see that.
You should see one slide, not.
I see one slide. I see all the other slides lined up on the left. Okay.
All right, I'm going to try this one more time.
What's wrong with this? Okay, whatever. Okay.
No, that's not what I want. Not what I want. Okay, we're gonna get it this time. I promise.
Okay.
Okay. See some buildings now.
I'm seeing tall buildings, beautiful buildings.
Now you see one slide.
I see. Yeah, well, I'm looking at one page. It's legal strategies for startup success. Yeah.
Okay, perfect. Now tell me that you see a disclaimer page.
I see a disclaimer. We're ready to roll.
All right. So
M&A framing.
Gotcha. All right. Okay. Not my fault. That's all Zoom. I'm not taking any responsibility.
That's right. Don't take any
for how clunky this is. So again, I'm Roger Royce. I'm a partner with Haynes Boone in Palo Alto. This is the 10th in a series, 10 out of 12. Legal strat of I guess we call it legal foundations or something like that. Legal strategies for startup success is the title of my latest book. This session is on mergers and acquisitions. And like Bob says, this is where we all want to get to, in a startup. We want to exit. And I guess it's possible to do an IPO, but usually my exit is an M&A deal. At least it has been for the last 20 years. Once in a while we go public. I took one public last year, but for the most part it's M&A. And we're just going to hit the high points of M&A. Again, as always, this is not legal advice. This is just information because change the facts, you change the result. Your facts might be different, etc. So let me tell you what I'm going to talk about for the next hour in terms of M&A, because we've only got an hour to cover a humongous topic. So I want to give you a summary, what kind of buyers to expect. This is startup land, so we're talking about private deals, but you might have a public acquirer. And we're going to focus on the key legal regimes. I have plenty of other content on my YouTube page about all the other issues that go into M&A, fit, transition, etc. But this is about the law today. So let's get right into it. But a few introductory items. You should understand there are different kinds of buyers that you are building your company for. And when we talk about, and that's typically strategic and financial buyers, and we talk about strategic buyers, what we really mean is an operating company that's in the same or maybe a related industry, and they're acquiring you because of the synergies, 1 + 1 is 3 kind of thing. And you're going to help them expand their product lines. You're going to enter new markets. Maybe you're just Reese's Pieces and you all fit together. And we expect that they may be able to pay you a premium just because you're going to get these operational benefits in synergies going forward as they integrate you into their business. The challenge, of course, is exactly that, the integration. And fact of the matter is most deals do fall apart because of lack of integration. But that doesn't mean I'm going to stop doing them because, we want to exit. We want to get a good exit. The other type of buyer you'll hear about is a financial buyer. And I'm setting the stage here because the issues are a little bit different. And that may be like a private equity firm. And we've been seeing in this Silicon Valley over the last few years, sort of this influx of private equity moving in, consolidating, rolling companies up. And they're looking for a financial return, not so much we've got an existing humongous company that just wants to add a product line or whatever. It's a much different sort of business. They'll often use leverage. They'll expect that they're going to have an exit even after they acquire you. And interestingly, almost always we'll see rollover equity in those deals, which I'll talk about later today. And that's not something you see with strategic buyers, but with these financial buyers, you oftentimes see that. And that introduces its own set of complexities. So it's a different kind of deal, different kind of currency, we'll call it deal currency, and really different expectation. So let's walk through the deal steps that we're going to talk about, because that's the first thing to think about is when does this happen? So the first, and I'll talk about the steps and then about the documents. But the first thing really is structure. I mean, that's the first thing I think about in a deal. As I said, is this a strategic or financial buyer? It's going to make a difference into what it looks like. Do you have a private or public company acquirer? It's probably going to make a difference in what it looks like. And the difference will often be what I call currency. What are you getting for your company? Are you getting cash? Are you getting deferred payments? Are you getting stock? Are you getting rollover equity? Something like that. The second component to this would be, what are they acquiring? Now, you as a seller almost always would prefer to do a stock sale, or from the buyer's standpoint, a stock purchase. And we used to say, for tax reasons, a buyer would always rather acquire assets because you get a step up in depreciable assets when they acquire assets, but they don't get that fair market value step up in those assets when they acquire stock, unless you happen to be an S corporation. We might get into that later. I do as many of those as probably anybody does. So, but as I said, you as a seller want to do a stock sale. And the reason why, you already know if you've been at any of our other 9 previous episodes, so you can get qualified small business stock treatment on the sale of your stock. You want to exempt that gain from federal income taxation. You get that with the stock sale. You do not get that with an asset sale. The corporation is going to pay tax at the corporate level on the sale of its appreciated assets. So we want to do it as a stock sale. The buyer, on the other hand, they're thinking, well, gee, if I buy the stock of the company, I'm getting everything, whatever's in that company, whether I know about it or not, contingent or real, and I might not be willing to take that risk. The second problem with that oftentimes is, I'm not sure you can represent to me who actually owns this company because you might not have kept good control over your cap table. So there are a lot of issues that would make a risk-averse buyer, want assets more than stock. On the other hand, the flip side of that coin is that whenever you do an asset deal, you almost always you're going to miss stuff, right? There's going to be some little piece of IP. There's going to be something that doesn't get scheduled. And, if the buyer just buys stock, they know they're getting everything that the company owns. In terms of papering the deal, it'll usually start with an NDA and immediately follow with a letter of intent, maybe both at the same time. But in my experience, typically we'll do the letter of intent first, and the seller will share with a buyer really high-level stuff, financials, head count, where you're located, what your business is. And we won't get to an NDA until they actually sign the letter of intent and then start doing deeper diligence, because buyers don't like to sign NDAs. And you really don't need it until you start giving them something that really is confidential, like what you're paying your employees or what your IP actually is, or something like that. So that's usually how I see it work out. Once that letter of intent is signed and an NDA is in place, then we start a due diligence process. And typically, we want to set up a data room. And in fact, I like to do this preemptively and just put a data room in place as soon as we incorporate a company and start populating it, because there's a saying in this business that time kills deals. And if you takes you time to gather up all your documents, load them into a data room, give everybody access, you're just adding unnecessary time to the process. And from the sell side, if it's a big enough company, you're going to want to consider what your obligations are. Um, and we'll get into that a lot more down the road here. So in letter of intent, NDA, diligence starts. And while the buyer is doing diligence, we typically will start, and typically the buyer will draft. It's totally the opposite in a financing, where the company drafts the financing documents. In an acquisition, typically the buyer does the first draft of the acquisition agreement. Not always, but typically. It doesn't really matter much, to tell you the truth, but there are some nuances, some subtleties to that. But we're going to negotiate the agreement regardless of who does the first draft. But typically, buyer will draft, so they're going to be doing due diligence and they're going to be drafting. And what they're drafting is a definitive purchase, stock purchase, asset purchase, or a merger agreement. And that agreement is going to have a long series of representations we'll talk about, and the seller is going to draft exceptions to those representations. And you'll know what I mean by that as we get into it. One thing about this, who drafts, I'll just pause on it now. Every once in a while, somebody will get the bright idea that, well, gee, seller, you draft because you'll get it done faster, because I, seller, am highly motivated to sell, and therefore you are too. Well, the problem is, if we as seller draft, we might give the buyer something in that draft that they might not have otherwise asked for, because we're trying to get to a middle of the road document so we get to a close more quickly. If I let the buyer draft, if they don't ask for something that they should have, I'm just going to leave that out, right? And if they ask for more than they should have, well, we're going to negotiate that away. So there's some strategy that goes into this, and that's why the market has always been, as long as I've been practicing, buyer drafts. Approvals, we'll talk more about this, filings and financings. Typically, you can't get a deal done in a vacuum. There may be consents you have to get from other parties, maybe a governmental approval, shareholder approvals, etc. There's two kinds of deals where we do a sign and close. We have one agreement. The day we sign it is the day we get paid, and we're done. Most of the time, that's not how it works. We sign it, and then we have a period of time, like maybe 30 days, to run around and get consents. Got to get the landlord to consent to the transfer of the lease. We got to get the bank to consent to the transfer of the stock. We got to get all these vendors have to consent. So there are closing deliverables. So we'll sign now, and then we'll go get the deliverables. And 30 days from now, we'll bring the deliverables back, and then we'll have a big closing. Closing mechanics. Oftentimes we use an escrow agent, sometimes not. Sometimes there's regulatory processes we have to wait until we get an approval or until a time period expires. And because there's a difference between when we sign and when we close, we'll have a certificate from officers of the company that will bring down the representations. I'll talk about what that means. And then post-closing, we're not done once we close and get the money, because there's going to be post-closing adjustments. It's going to take a while for the accountants to figure out what it is that the buyer actually bought in terms of your accounting treatment. So there may be some adjustments to the price based on how much working capital you promised and delivered, and how much debt there was, etc. Also, post-close, there's going to be a period during which there are indemnities. In other words, you as seller are going to represent to the buyer a certain set of facts about your company are true, If they turn out not to be true, buyer is going to have an indemnity claim, and they've got an agreed upon survival period in which to make those claims. And then, of course, there's going to be tax filings that are due after that. So deal structuring, I gave you the high level. Let's kind of drill down a little bit. So the questions when somebody comes along and says, we're going to sell our company, we've got a buyer, they're interested. Here are the questions to ask, high level. Number one, is this a stock deal or an asset deal? Or is it a merger? And it could be any of those three or some combination. Is it a taxable or tax-free deal? And that usually depends on what you're getting in the deal. Are you getting mostly equity or are you getting mostly cash and deferred? If it's mostly equity, and by mostly I mean more than 50%, then we can treat it as a tax-free deal to the extent of the equity, never to the extent of the cash, but to the extent of the equity. And that makes it it makes it a merger in effect, or some other type of reorganization that we'll talk about. And that ties into the next issue. What are you getting? You're getting cash, you're getting equity, you're getting deferred payments, you're getting earnouts. So we have to answer all these questions up front. We usually resolve those in the letter of intent. Now, stock deals can either be a stock purchase, which is very simple. Here's our stock and you give me cash. If there's more than a handful of shareholders, you won't see it that way. What you'll see instead is what we call a reverse subsidiary merger, or maybe some other type of merger. And the point is that in a merger, the parties can force the minority shareholders to go along with the deal. So if you get more than 50% of the vote, then you're doing the merger, and you don't have to get a signature. You don't have to get a consent from your minority shareholders. A stock purchase, by definition, you have to have 100% of the stockholders to sign up. So it really depends on your shareholder base. But for tax purposes, and actually just effectively a reverse subsidiary merger gets you to the exact same place. When the smoke clears, and I'll show you the mechanics later, when the smoke clears, the buyer owns 100% of the stock of the target. So that's why I have that under stock deals. Asset deals, either, as we discussed, purchase and sale of assets, but you can get to the exact same place doing a forward merger as well, in the same, similar considerations. And if it's stock consideration in the deal, if it's a tax-free deal, then you would do that as a merger. And in a merger, basically one company goes out of existence and another company succeeds to all of its corporate attributes, assets, liabilities, contracts, everything, etc. So it acts very much like an asset purchase. That's why I have forward merger under asset deal. Okay. As I said, a merger, just to define terms and level set here, we have a target, we have an acquirer, two more corporations combined, but only one survives. That's the definition of a merger. And the other part about this is it happens under state law. So everything moves by operation of law. We don't have to get a bunch of bills of sale or assignments or anything like that. It just happens as a matter of law. We file a document with the Secretary of State, and poof, now acquirer or corporation owns the asset instead of target, and has the liability of target as well. So again, to level set and define, when we say forward, usually we'll do these as subsidiary mergers. And what do I mean by that? Well, remember what I said. In a merger, the acquirer is going to pick up all the liabilities of target. Well, what if there's stuff out there that you don't know about and you don't like, and you might not want to pick up? Maybe there's some harassment, lawsuit that has yet to be filed, or maybe you violated one of California's Byzantine AI laws and didn't know about it, and data privacy, or maybe a million other things like that. So an acquirer says, I'm not going to bet my entire company on this set of unknown liabilities. I want to isolate those liabilities. So instead of me, the acquirer, being the merger party, I'm going to create, or the acquiring merger subsidiary, I'm going to create a subsidiary that acquirer owns 100% of. We'll call it merger sub. And merger sub is going to merge with target. And the reason I'm doing that is if this whole thing does blow up, and there is some huge liability that we've taken, well, I've isolated it down at the merger sub level. That is how these deals are typically done. Not always, but I'd say more often than not. Now, there's two ways you could do it, and that's the two ways that I've got listed here: forward merger or reverse merger. And in a forward merger, the merger sub is effectively going to acquire the assets. And in both these cases, Target goes out of business, but the assets are moving over. And effectively, in a forward, Target goes out of existence, and merger sub survives. So acquirer ends up owning 100% of the stock of merger sub, which owns 100% of the assets of Target. In a reverse, it's the target that survives. So acquirer owns 100% of the stock of Target because merger sub goes out of existence in the transaction. That's why I say it looks a lot like a stock deal. Okay, I'm going to hit some of the regulatory issues, but they're even in a startup environment, we've got these regulatory requirements that we sometimes have to deal with. So let's talk about them. One is CFIUS, which I'm sure we talked about in a prior presentation on international. But CFIUS, Committee on Foreign Investment in the United States, it's something that it's just one of those annoying things that just seems to be everywhere these days. But it is a filing, and it's mandatory for critical technology. Other deals, it's voluntarily filed. And there's a short form and a detailed notice that basically we have to file that. And then we have to give and there's a 30-day review period. So it could hold up your deal by about 30 days. Another reason we have deferred close deals. If no issues are found, a transaction is clear, not a problem. If there are concerns, oh, gee, you're transferring critical technology to China or something like that, well, then CFIUS can launch an investigation. And theoretically, it can move all the way up to the President of the United States as to whether the deal gets done or gets unwound. And you may have read in the papers, there are deals that have been unwound because of CFIUS and companies forced to divest. Think of it as similar to an antitrust sort of determination, but it really is an international IP export protection sort of regulation. But it's something we need to be aware of, especially here in Silicon Valley, where everything is a technology company and critical technology is somewhat broadly defined. It will include sensitive personal data, by the way, just so you know. Second regulatory issue to think about, and this is really a tax issue. I probably shouldn't call it regulatory, but seems to fit that category, is FIRPTA. It's been around since Bob was a young man. Foreign Investment and Real Property Tax Act of 1980. It applies if your target company owns real property, real estate. That's almost never the case in my business, but keep in mind, real property can be a long-term lease too, so be careful. If it does, then we've got a potential withholding obligation. Usually, I mean, we always have to think about it. It almost never applies because we just get this affidavit or a FIRPTA certificate, we call it, at closing that says one of two things. Our seller is not a foreign person, because what we're trying to do is tax foreigners on a sale of U.S. real property that they might not otherwise be taxed on. Or number two, the target doesn't hold any real property. It's not a U.S. real property holding corporation. But if you don't get that certificate, then your buyer is taking all that risk if there's no withholding, which there won't be. Hart-Scott-Rodino, on bigger deals, we have to deal with HSR. And it's an antitrust provision. We notify the FTC and the Department of Justice of deals that exceed a certain size. These limits change frequently every year, I think. And then there's a waiting period. So again, we might have to have a deferred close. And either the regulators clear the deal and maybe even early, so you can go ahead and close, or they demand more information, or maybe they block the deal under antitrust law. So HSR, when you've got bigger deals, it's one of those annoying filings we have to do. It's also really expensive, by the way. The HSR fees are It's just another hurdle. Finally, I want to mention people tend to seem to forget that, the securities laws still apply, even in an M&A. You might think you're clear of the securities laws when you finish your financing, but you're not, because if you have an M&A deal where the buyer is using stock or securities as the currency, guess what? They're issuing a security. And remember what I said way back when, how we don't want non-accredited in our company if we can help it, non-accredited investors. Well, this is one of the reasons why, because when that buyer on the back end doing the M&A issues its stock to your shareholders, Mr. Target, well, if your shareholders are not accredited, you've kind of taken away some of the exemptions that they might have otherwise used to issue those shares. And sometimes this can be a real hassle. I mean, in fact, I've had to do this a few times where we've actually had to go to the state of California and get a permit, a securities permit to do our deal because we had unaccredited investors in our deal. But that's a little bit maybe beyond our scope here. Suffice it to say that we do have to consider the securities laws both on requiring finding an exemption from registration, and then secondly, our anti-fraud rules. Which just ensure that our shareholders get accurate and complete information, which is why you will oftentimes see in these deals, shareholders present it with an information statement, a detailed information statement about the deal, what's happening, what they're getting, etc. And technically, yes, the tender offer rules do apply. If it's for securities other than exempted securities, including equity or debt of non-reporting companies. So what I'm trying to say there is, yes, it applies even though you're a private company, when you've got a buyer going out and making an offer to all of the shareholders of the company. It's another thing we need to be aware of. We need to deal with the notice requirements and the time frame, but unless you're planning on trying to buy shares from some shareholders and not others, or on different terms or something like that, it is not going to hold up your deal. It's really more of a notice provision and a prohibition of any false or misleading statements. Okay, getting back into the key transaction documents, let's drill down a little bit as we discuss. First of all, the letter of intent. Your letter of intent, and I see them frequently, will just set forth in summary fashion the material terms of the deal. And you can see why. We want to know if we got a deal before we go forward. Now, the letter of intent is typically going to be non-binding, theoretically. In other words, there's not nearly enough meat in this 2-page letter for us to conclude a deal. So we're not going to bind you to it if something comes up, but we want to know what your intention is. So we'll put it in writing. Now, even though it's non-binding, in many states, most states, maybe even all, certainly in California, the courts will impose an obligation of good faith and fair dealing. In other words, the courts will assume and require you to be bound by one provision for sure, regardless of what you say, and that is that you really intend to do what you say. And a bad faith claim is a hard thing to make out, but it's not something you ever want to risk. So take that with a grain of salt that it's non-binding. You still can't be doing this in bad faith. And by bad faith, I mean with no intention to fulfill any promises you're making in writing. We'll have confidentiality provisions in the letter of intent, oftentimes the first time ever in the deal between the two parties. You used to see breakup fees, not so much anymore, but sometimes. And that's the idea that if the deal doesn't close, somebody's put a lot of money into this, usually the buyer, and they want to be reimbursed for their legal expenses or whatever if they don't close. I've seen it go the other way too, by the way. It might be like sellers like, well, you've taken me off the market while you do your diligence, so we get money if you walk away. I just don't see those that often anymore. But you will always see a no-shop. And that is a clause that said, look, during the next 60 to 90 days, while you're negotiating with us to close this deal, you're not going to talk with any other potential buyers. You're not going to shop the company. Not only that, you're going to come tell us, the buyer, if anybody else even approaches you wanting to buy this company. and you will always see no shops in these deals. Okay, after signing a letter of intent, we typically move quickly into due diligence. And like I say, get the data room, have that all teed up and ready to go. And the due diligence is a process where the buyer identifies the risks, the liabilities, and any compliance issues. And I've listed kind of the key areas here that they're looking at. We're going to go through these in more detail in a minute. It's worth considering the fiduciary duties of the board at this point because the board does not act in a vacuum. And number one, are there any conflicts in these deals? For example, a lot of my companies, they have VCs on their board. Are they engineering a sale of a company to another company they've invested in? If there's stuff like that going on or anything that even looks like a conflict, it's a good idea to form special committees. Sometimes we get fairness opinions. And that's an opinion by an investment banker that consider the exchange rate is fair, right? So if I'm trading, every 2 shares of stock in my target for 1 share of stock of the acquirer, we might get an opinion of an IB, an investment banker, that's a fair number to protect us from liability as directors. And then there's this concept of fiduciary out, which you'll see in the documents that basically says, look, we'll bind ourselves to do this deal, but we have to have an out. I mean, if a better offer comes along, we might have to take it just because that's our fiduciary obligation to our shareholders. So, but you'll only see that in companies that are a little more widely dispersed shareholding. I'm going to talk a whole lot more about board fiduciary duties next month when we talk about troubled companies, because usually, let's be honest, as a practical matter, in a typical case, an M&A deal is a very happy event. People aren't complaining about it, right? It's only when you have a down, when you have an unsuccessful or troubled company exit that we really get those complaints and have to think a lot about it. But we still want to go through all the procedural steps and make sure we've checked those boxes and done our diligence. Now, we're waiting on a definitive agreement while due diligence is happening, and eventually we're going to get it. And you as a seller are going to be sitting there wondering, why is this taking so long, for us to get this agreement? I'm going to tell you why it's taking so long. It's not because the lawyers are lazy. It's not because they're too busy doing other things. It's not because it's just so difficult to draft. It's because they're kind of waiting until you get as much information as possible in due diligence, because that is going to inform that definitive agreement quite a lot. It's going to inform where the carve-outs are from the indemnities, how robust the reps and warranties are going to be, might even adjust your purchase price. So, but eventually you are going to get a draft. In it, it's going to have all of this stuff. So let's kind of go through it. First of all, what are we buying? If it's an asset deal, and even if it's a stock deal, your agreement may be specifying what it is that the buyer is taking and what they don't want. And we call what they don't want unwanted assets. And there are techniques for disposing of unwanted assets prior to close. Same with liabilities. There are liabilities that we might know about that we're not taking. The only way you really do that if you're a buyer is by doing an asset deal and just specifying these are the included liabilities, everything else is excluded. Now, I want to pause on one thing in excluded assets, because this has to be in your agreements. And I've seen very good law firms mess this up, but not so much anymore. But you really want to specify who the emails belong to. Because if the seller's count, keep in mind, the seller will oftentimes, usually represent the target company. And when a buyer buys that target company, you may get a letter from the buyer's counsel right after that saying, we now own the company, which owns the emails, so give us all the emails. I want to see what you and your lawyer talked about prior to sale. And let's just say I've seen that happen, and I've seen the result be very ugly. So you never want that to happen. So we exclude those and all other attorney-client communications, and in fact, the entire attorney-client relationship, because it's really hard for your seller client to be completely transparent with you as seller counsel if they're worried that the buyer is going to be reading all of the emails, looking at all the letters, deposing them on all the conversations. So we generally just spell that right out in the documents. Purchase price will have many components to it, typically cash at close, buyer stock or equity, sometimes debt, deferred payments, we're going to pay you later, contingent consideration, and earnouts, which is a whole thing in itself I'll get to, and then holdbacks to satisfy indemnities. Sometimes if you have a stock for stock deal, you'll see what we call a collar. And the idea behind a collar, if you got a public company buyer, you want to get X dollars worth of stock. Well, if that's a volatile stock, well, what happens when it fluctuates? It goes up and down before close. So you'll put what we call a collar, and that's just a range. Let's say, look, if the price stays within the collar, it's going to be 10-to-1 exchange ratio. But if your stock price moves, we're going to adjust the exchange ratio so we know we're getting some amount of value. I had a deal once where I was on the sell side, and the buyer messed up the collar because we had a collar, but it only went one way, and it was unlimited the other way. So, in other words, their stock went super high by the time we closed, way higher than anybody expected. But our collar was only on the bottom end, so we ended up, getting 4 or 5 times what we expected for the company. That does not happen very often, maybe once in a career. All right, employee carve-outs. We will, in my world, the employees are super important when we have a sale of the company. And oftentimes we can take care of them through the option plan if it's a well thought out, well designed company. But sometimes the options just don't quite get you there. So we'll do what we call a carve-out plan, which is just a portion of the purchase price that we put into an escrow or an account and use that as a stay bonus for employees to come along and continue to help work and support and transition. And those can get to be fairly complex because they might be subject to earnouts, they might be subject to milestones, metrics, but just expect to see that very often. And it's, by the way, it's also subject to special tax rules. We got to get tax clearance on this because we got that pesky 409A to deal with that we talked quite a lot about in prior episodes of this presentation. Let's talk about purchase price adjustments. And you really, I know people want to do deals without purchase price adjustments, and that's the way they do them in Europe. It's not the way we do them here. And the idea is that almost always companies are acquired on a cash-free, debt-free basis. And by debt-free, we mean long-term debt. And if it turns out that the company has a little, because you're going to have some cash in a company. We say debt-free, cash-free, but you're going to have some cash. You're going to have to pay your employees, right? So you're going to have some cash on day one of acquisition. You're also going to maybe have some debt because maybe you didn't pay the debt off at close. And if that happens, we adjust the purchase price. Goes up for the cash you got, goes down for the debt that you promised you would not have. Similar to that is the idea of a working capital adjustment. And remember what I said, for cash-free, debt-free, we mean long-term debt. So what do we do about short-term debt? And what do we do about receivables and cash and, and other current assets? So that's the working capital adjustment. And I know everybody wants to, it's so complicated, let's do it without it. And part of my job is to talk you out of that idea because you really don't know what you're going to get unless you get a good working capital adjustment mechanism. And the idea is we say, look, this company has got a normalized or average working capital of X, and that's current assets minus current liabilities. Put a pin in that for a second, but let's assume that's what it means. So what happens when we have more than that current working capital at close or less? Because we got to leave some money in the company to run. We can't just shut the company down on sale. We want it to continue to operate as a going concern. Well, then we adjust the purchase price. Now, a couple things about that. I have come around to the view that you don't ever just say working capital anymore. You don't even say working capital as determined by GAAP, because whose GAAP are we talking about? We did a whole episode on accounting, if you remember a couple episodes ago. So what I like to do is define working capital very carefully and even use an example sometimes and say, this is what we mean. These are what we mean by current assets. These are what we mean by current liabilities. This is what we're measuring. We're not measuring deferred tax assets. We're not measuring deferred tax liability or accrued tax liabilities, right? Stuff like that. Just define it, because otherwise it'll be an argument of accountants. And then finally, the dispute resolution mechanism, because these things are often disputed, or sometimes I should say. And the way the dispute resolution provision works is that, look, this is all just math. It's all just numbers. It's all just accounting. We're going to get the accountants together and just agree on it. But the important part about that is that the clause that says, but the accountant is not acting as an arbitrator. And that might sound like a bunch of legal mumbo jumble. That's just words until you actually go through it. Because sometimes it's just accounting and just numbers, but oftentimes it's not. It's a matter of contract interpretation. Like, what did you mean by that? And what does this term encompass? So you want an arbitrator to decide that when you've got the opportunity to present evidence and make arguments. You really don't want to defer that to the accountants, but you do want to let the accountants resolve any of the accounting issues. I've included a sample working capital clause, but you get the idea. There's a sample definition of working capital, so you get the idea. We define it. And you'll get these slides. Just ask me for them if you want to see the slides, if you want to look at that at your leisure. Contingent consideration, this is earnouts. What we mean by this is that sometimes we say, look, I think your company's worth 10 million. You think it's worth 20 million or 15 million. Tell you what, how about we give you 10 now, and then we give you some percentage of either the gross income or the net income going forward to kind of bridge that valuation difference. So that was the original idea behind it. Of course, now clever lawyers will use earnouts as a way to increase the purchase price beyond what it's actually worth. It's one way of looking at it. The litigators all agree that an earnout is a great way to guarantee litigation because depending on your perspective, an earnout is either never earned or always paid, one or the other. And there just are a million ways that we can have disputes over earnouts. One way is accounting method. But again, we can carefully define, what the metrics are. The bigger issue is usually duty support. So it's kind of like, look, then the dispute is usually, well, you buyer, you didn't support this business. You starved the business. You fired my key employees. You stopped doing advertising, blah, blah, blah. And therefore, it's your fault we didn't hit the earnouts and you owe me that money anyway. That is the hugest litigation risk. And I try to tie that up as much as I can with the language, saying this is exactly what the parties are going to do. These are our expectations. And, we really want to minimize the risk of liability because an earnout is a powerful thing. I mean, we really want to do this if we can, but I don't want to be marching my clients right into future litigation. And then finally, people don't think about this enough anymore, but an earnout probably is a security. So a buyer that's doing an earnout, I mean, if you think about it, it fits the standard definition of security. And it's something worth thinking about. It'll never hold up a deal. It'll never stop a deal, but it's worth thinking about and planning for. Okay, that I just talked about. There's a earnout support clause. I put a sample in the slides. And in closing, we already talked about this except for conditions to close. You're going to get all these consents we talked about, escrows and holdbacks. Let's get into that a little bit more after reps and warranties, since we're getting towards the end of the time. So reps and warranties. And so question number one, the representations and warranties. The seller or the target is going to represent that the company has a certain set of facts that are true. So what do we mean by that? Let's use an example. One would be organization standing and power, right? We're properly organized. we're allowed to make this, to enter into this transaction. We have the power to transfer these shares or transfer these assets. This is authorized. There's no conflict with any other agreements by doing this. So that's an example of the first, what we call fundamental rep. Who makes that rep? Well, the target company for sure, but that's the kind of rep you would expect a seller to also have to stand behind. Buyers make reps too, but less so. What other representations will you see? Well, target company or seller company, we've given you buyer financial statements, and we're going to rep and warrant that those are fair and comply with GAAP or whatever our accounting system is as of the date that we gave them to you. We're going to represent there's no undisclosed liabilities. There's no changes in our business since the day we signed this agreement until we close, or since the day that we signed a letter of intent until we close. That there's no litigation that we haven't told you about, et cetera, that we have title to assets, right? And what's the consequence of this? Well, think about title to assets. Suppose the company doesn't have good title. And it's sort of like if you sell someone a car and you don't own a car, well, they should get their money back. That's kind of the concept behind reps and warranties. If it's not true, then, the buyer gets some portion of their money back. This is the biggest part of the definitive agreement. This is the part that's most heavily negotiated. This is the part that we spend the most time on, because for all these reps, we, the seller, have to attach a schedule of exceptions. Like, where the rep says no litigation? Well, except for see schedule of exceptions. We got sued for this, we got sued for that, we're suing somebody for this, that kind of thing. And that makes the agreement not, you won't be in breach of the agreement when you sign it because of that schedule of exceptions. I won't go through all of these reps and warranties, but this is a handful of them. Environmental, taxes, you get the idea. Pretty much every little single risk. Now, you might say, well, do we really need all this? Why can't we have just one rep and warranty, that says everything that the buyer should know about, we've told them about? Yeah, good luck with that, because you always want more specificity rather than less when it comes to this sort of thing. Because when the buyer wants to sue the company or wants to withhold some of the holdback of the purchase price to satisfy a breach of a rep and warranty, they're going to want to have a specific rep to point to and say, right here, this is the one. Disclosure schedules we talked about. You'll see this concept of materiality scrapes. What does that mean? Well, the rep and warranty, a lot of the reps are going to say, look, we can promise you that there are no material unpaid taxes. Not going to say there's no taxes at all, because who knows, I might have missed a $50 withholding tax somewhere along the line, but no material. Or it might say no material whatever litigation, and that tends to be fairly heavily negotiated. So a scrape says, and there's two types, a single and a double scrape, and we're scraping the materiality off of the indemnity. So it says when we find a breach and the buyer comes back and wants to withhold some of that holdback or escrow, or maybe even sue the seller for breach of the rep, we're going to determine, for a single scrape, we're going to determine whether the rep was breached without regard to materiality. Okay, you breached the rep even though it was a less than $50 tax that you paid. So there's a breach. That just tells you what the breach is. Doesn't tell you how much the buyer recovers, just tells you that there has been a breach. We get to that at the next stage. Double scrape says, not only are we going to disregard materiality to determine a breach, we're not going to consider it when we calculate our losses. And that's rare. Typically you'll see a single scrape. A double scrape is actually pretty aggressive. But that's just so you know what they are. And again, heavily negotiated. We're going to get into indemnification in the middle. Dispute resolution, closing covenants. I think we all understand that. I think we talked about this. There's a certain set of facts will have to be true before the buyer is obligated to close. We will have covenants after the closing, right? Because there's stuff that has to happen after. Tax returns come to mind. Maybe there's some IP assignments or patent filings. Another oftentimes condition of closing, what we call the MAC clause, material adverse event clause. And it's just a representation that there has not been any material adverse event that occurs basically between signing and closing. And if there is, then the buyer can walk, and you can understand why they'd want that. And by the way, these things do have significance. I mean, I remember doing a deal right before the COVID lockdowns. And my very smart seller had an idea that was coming. And so we negotiated that out of the MAC clause. So even though everything got locked down before close, the buyer still had to close. And it was in a business that got closed. I'll tell you which one. Indemnity. So the indemnity is the idea that the buyer is going to have a claim for breach of reps, and someone's going to have to pay that claim. And who's it going to be? Well, typically in a stock sale, for sure, it's the stockholders, maybe not all of them, but the significant stockholders. And the first thing that comes up is, well, who is it, joint? Is it several? And the difference is joint and several means that every single indemnitor, meaning every stockholder who signs up for this, is personally on the hook for up to 100% of the claim. And then they can go sue the other, indemnitors if they want. Several means that they're only on the hook for their pro rata share of the claim. I'm a 50% stockholder. You can only sue me for 50% of your loss. You will usually see joint and several. We'll try to get several. Kind of depends on the company. Fundamental reps are reps that have an extended survival period, maybe forever, like title. Remember what I said? If you don't own a car, you should get my money back for buying the car, right? That would be a fundamental rep, title. Deductibles and baskets, the idea is you don't want to be bothered by every little nickel and dime claim. So we'll set a limit, like you don't have an indemnity claim until your losses exceed this number. And then the difference between a deductible and basket, do I have a slide on that? Is that the deductible means that the buyer picks up the losses up to an amount before the seller pays anything. And there's a tipping and then there's a basket, which is just a threshold before the buyer's on the hook. And there's this idea of a tipping basket that once you're over that basket amount, then the buyer gets all the losses starting from $1. I have an example there, but you get the idea. Indemnity caps, we will typically cap indemnity because and survival periods, and we'll put a time limit. 1 to 3 years, usually 18 months. Indemnity cap, I shoot for 10% typically of the purchase price. And the idea is at some point, this is business risk, right? At some point, we, the seller, have to stop looking over our shoulder for potential claims, and you, the buyer, just have to assume you're taking this business subject to whatever warts it has. All right, I want to talk about tax. Well, let's put a pin on that. I want to get to that in a minute, but we're running out of time. Rep and warranty insurance, I see it less now than I did a few years ago, but this is the idea that, look, I'm a nervous seller and, I just want to go insure against breaches of reps and warranties, and you actually can. And a few years ago, almost all deals were done with RWI. Seems to be less now. It's relatively expensive. There is a retention or a deductible that's held back. Cost typically, will be negotiated who pays for it, but typically split between buyer and seller. And that is a whole thing in itself. We could do an hour on RWI. I just want to mention that it's out there. And you can insure against almost anything. You can get tax insurance, in fact, on these deals. Escrows and holdbacks, I think we touched on. Will be transitional services. I want to hit with the last 5 minutes here some of the tax stuff. Because remember what I said, we have to decide if it's taxable or non-taxable. What I've just given you is kind of the high level of the general terms, but let's say it's a tax-free deal. Well, here are all the, okay, well, let's talk about that. So there could be a type A merger, tax-free merger. There could be what they call a type B, stock for stock deal, tax-free, or a type C, a stock for assets deal. And let me just pause on them briefly, just so you're familiar with the terms when these come up. But if you do get into these deals, the tax side can be involved and complicated and technical. And sometimes in the old days, everyone would ask for tax opinions when they did these, but those are super expensive. So we don't see that so much anymore. Merger, we'd already talked about. One company goes out of existence, the other company succeeds to everything. For tax purposes, we have to have, do I have a slide on it? We have to have what we call continuity, meaning that there has to be a sufficient amount of equity in the deal. In other words, you, the shareholder or target, you're just continuing your interest in this business through a different entity, acquirer stock instead of target stock. Well, that works if there's, at least 50% acquire a stock in the deal. If there's very little acquire a stock in the deal, well, then you're not really continuing your interest. You're cashing out, and all of the consideration, including the stock consideration, is going to be taxable. That's what we mean by continuity. It tends to be the biggest issue in these deals. Stock for stock deals we hardly ever see because they're so delicate, meaning that it's really easy to blow this. And the reason why is there's this concept of no boot in a B, and boot is non-stock consideration. So we swap a target stock for acquirer stock, but in the process, the acquirer may pay some of the shareholders' expenses. We just blown our deal. Now all the stock is taxable. There's better ways, easier ways to get there. Merger, typically. And then once in a while, we'll do what we call a stock for assets deal. I won't go through all these technical details. I've got hours on this on my YouTube channel, but this is where we have the kind of company where we just can't transfer all of the assets, but we want to do it as a tax-free deal. So we transfer the wanted target assets in exchange for acquirer stock, and then target liquidates and transfers its target stock to shareholders. We can do that tax-free, provided we meet a bunch of these numerical requirements. Triangulars, we talked about. There's some additional requirements when you have a reverse subsidiary as opposed to a forward. Parachute payments, just be aware that sometimes there's an excise tax and a loss of deduction if management is getting a big, huge bonus, a deal bonus. That is a tax and an excise tax and a penalty provision that has loopholes in it that you could drive a Hummer through. So we just have to know about it and then go through the proper steps to avoid that happening. But just understand that there is this concept of parachute payments. And the steps to go through that happening is to get stockholder approval. And that stockholder approval has to actually determine the right of the shareholders to the payments. You might think, well, what if they don't approve? I have never had that happen in all my years of practice. All right, these are the private equity deals I was talking about. You'll see here that we've got, this is one type, and what I mean by rollover is what's effectively happened is we're putting a bunch of entities in place so that your stockholders, they're taking a pretty big, chunk of the acquiring entity as part of the consideration. And we want to do this in a way that's very tax efficient. In our last 2 minutes, that's all I'll say about that. I wish I had time to talk more about installment sale. Just understand this is a bit of a trap because it only installment sale reporting, the idea that you only pay tax on a consideration you receive as you receive it, that applies up to $5 million a face amount. You could split that between husband and wife. In other words, each gets $5 million, but nevertheless, it's only $5 million. If you blow that, then you got to pay an interest charge and you lose the benefit. Sometimes people miss that. With that, we won't get into S corporations. That is a whole other thing, doing sales of S corporations. There's a lot of planning opportunities we can do with an S corp. We can get a much better tax result. We can't get QSBS, but we can get a one level of tax result with an S corp. So something to keep in mind. So with that, I'm sorry I rushed through the last sections on tax, but I know how hard it is to stay awake through that. The slides are available for anybody who wants it. It is now the top of the hour. I want to thank you for being here. My name is Roger Royce. I'm a partner with Haynes Boone in Palo Alto. I do emerging growth and venture capital. I'm also the author of 2 books on startup law. One is Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup. My second one, 10,000 Startups, Legal Strategies for Startup Success. And thank you for attending, and thank you, Bob, for being my introducer.
Okay, Roger, that was good. Good job. Thanks, everybody.